Hi everyone, welcome to Beyond the Evidence. This is the channel where justice matters. My name is Marv. I am a true crime fanatic, and I love to dig deeper into the mysteries of unsolved cases. Join me as we search for missing persons, uncover the clues in unsolved murders, follow along with jury trials, and we'll be a voice for the voiceless. I'll share with you the facts, the theories, the clues, the evidence, and the controversies that surround these cases. This is Beyond the Evidence. Hello, everyone. Good afternoon. We've had some documents drop in the Delphi case against Richard Allen, and we're going to go through those documents right now. Buckle your seatbelts. Things are about to get hairy with Judge Gull. First of all, I just want to take a couple and acknowledge those that are here watching with us live. Curious Contrarian, nice to see you. Elemento P, love your name. It took me a second and then I got it. Jean Williams, good to see you. Gail, you too. CJK, glad you're here. Rose, thank you for being here and being a moderator on our channel. We appreciate it. Hello, Lynn. How are you today? Yvonne says, hello, Marvin chat. Right back at you, Yvonne. Jill, so nice to see you here. You've been with me since pretty much the beginning. Hi, Sherry. How are you? World is mine. Good afternoon. There she is. Andrea, another moderator, my bestie. Thanks for joining us today. And Jinx is here too. She says, welcome y'all. Please hit the like and subscribe. Let's see here. Who did I miss? Nobody yet? All right. Well, we're going to get started then because we have 21-page document and it's going to take a little bit to get through that. You know me, I read all of it. That way you know what's in it. I don't just summarize it, I read it. And then we got a couple short exhibit documents that came out today. Mother of Dragon, thanks for joining us. It's kind of nice to be able to do this right away once the documents drop and not have to wait till after work to do it. So I am going to put the document on the screen. Here we go. So this was filed yesterday at 10:58 a.m. Carroll Circuit Court, State of Indiana versus Richard Allen. Okay, so the title of this one is Accused Response to this Court's May 31st, 2024 Order or Judgment of the Court and Notice of Conflict. Right there, that key word, Notice of Conflict. Here we go. Comes now the accused Richard Allen by and through counsel and files his response to this court's May 31st, 2024 Order of Judgment of the Court and Notice of Conflict. In support of said motion, Mr. Allen states the following. On May 31st, 2024, this court issued its order or judgment of the court concerning the defense's request to have Judge Gull disqualified. Contained in said order were several errors. The defense is filing this motion to preserve those errors for future courts, if needed, and to notify the court that due to new information learned in her order, a conflict has been revealed which has caused Judge Gull to become a witness. What does that mean? Well, through my trial experience and watching other trials, I know exactly what that means, and I'm going to tell you here. If a judge becomes a witness in a case, they can no longer preside over the case, which means Judge Gull would have to recuse herself based on the fact that she is a witness. And a new judge would come in. Aha! So let's see if what the defense is stating warrants Judge Gull to become a witness. The defense files this response and notice for purposes of maintaining a record and does not wish for this pleading to delay future hearings from taking place. Yeah, right. Particularly hearings related to the defense's request to transfer Richard Allen out of the Department of Corrections, which is the most urgent of the pending matters that need litigated. Also, the defense's response is intended to provide correct information to Judge Gull as she continues to self-evaluate her obligations to recuse herself from the case should she believe that bias or the appearance of bias exists. Footnote: a judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. Abney versus State. So what are they accusing Judge Gull of now? Judge Gull failed to inform the defense that Carroll County Sheriff's Office fabricated facts in a report filed in her court. In his motion to disqualify, Mr. Allen noted that according to a June 14, 2023 report filed by the Carroll County Sheriff's Office, hereinafter CCSO, Judge Gull advised the CCSO that it could ignore a valid defense subpoena for Westville Correctional Facility inmate Robert Baston and refused to transport him to the June 15, 2023 hearing on Mr. Allen's emergency motion to modify the safekeeping order. The defense further alleged in its motion to disqualify that because of Judge Gull's actions, the defense was without a key witness for the hearing. It was anticipated that at the June 15, 2023 hearing, Mr. Baston would testify as to the harsh, abusive, and unconstitutional treatment of Richard Allen at Westville Correctional Facility. The failure of the CCSO to transport the witness from Westville left Mr. Allen without crucial evidence for the hearing, thereby subverting justice for him. Now, everyone in chat, remind me, because I haven't read everything, but didn't Mr. Baston refuse to go to that hearing himself? And that is why the judge said don't transfer him? Am I correct in that? Let me know in the chat. However, in her May 31st, 2024 order, Judge Gull claimed that she never advised the CCSO to ignore the subpoena and leave Baston behind. Judge Gull's claim contradicts the CCSO report that this court received on June 20th, 2023. So then my question is, who was wrong? Judge Gull or the CCSO? Did they put in misinformation in their report? Because if it's on them, it's not Judge Gull's fault, and she's not a witness. Okay. So Jinx has verified Yepers. He refused himself. That's what I thought. On June 14th, 2023, report, which was ordered by the court, stated the following. On June 14, 2023, a special deputy, Wazaki Bryan, while on duty, was conducting transport from Westville Correctional Facility to the Carroll County Jail. Upon my arrival, I was escorted to Baston Robert Segregation Unit to conduct the pickup. After waiting, a correctional officer approached and told me Baston is refusing to come out of his cell, and told the corrections officer, F you can't make me go. The corrections officer told me they will do a cell extraction to get him to my transport vehicle. I told the corrections officer to stand by, let me make a few phone calls. I was escorted back to the main gate where I was greeted by John Gillipue. I called Carroll County Jail Commander Lori, who I explained the situation to. She then made a phone call to Chief Deputy Tobe Lesenby, who contacted Judge Francis Gull's office to inform them of the situation. Judge Gull's office advised to leave Baston there if he did not want to attend the court hearing that is scheduled for 6/15/2023. I then spoke with Warden Gillippo and asked if he could provide me with a letter stating that Baston refused to come out of his cell and he didn't want to go. Warden Gillippo agreed he would. He later advised me he would bring me the letter on 6/15/2023 to Carroll County Courthouse so I could attach it to his report. Nothing further at this time. Silas, you are absolutely right. So apparently, Baston refused to go, and if he had been forced to go, he wouldn't have given them the information they wanted in the first place. He would have been a hostile witness, absolutely. The report was approved by Tobe Lesenby, who is the key witness in this case. Just opposed to the CCSO judge is Judge Gull's May 31st, 2024 order, in which she stated, the decision by the deputy to leave without the witness was his and was not directed by the court. The first time that Richard Allen's counsel learned of these contradictory stories was in Judge Gull's May 31st, 2024 order of judgment of the court. Judge Gull has possessed this report since June 20th, 2023. Upon receiving this report nearly a year ago, Judge Gull never notified Mr. Allen's attorneys of the misrepresentation contained in the report as it related to her purported involvement in the failure to transport Mr. Baston to the hearing. At the very moment of learning that CCSO filed a report with fabricated facts, how many times have we heard that law enforcement or Lesenby or Holman has fabricated facts from the defense? How many times? I mean, this is their go-to. This is the defense's go-to when things are not going their way. At the very moment of learning that CCSO filed a report with a fabricated facts concerning Judge Gall, she should have immediately alerted Mr. Allen's attorneys of the misrepresentation contained in the report. Further, upon Judge Gall learning of the misrepresentation contained in the report, which undermined the evidence, Mr. Allen was able to present Judge Gall never reset the hearing so Mr. Allen could present the very evidence Judge Gall said was lacking when she denied Mr. Allen's emergency motion to vacate safekeeping order. Additionally, as this court is aware, Mr. Allen has filed 4 Franks motions indicating that law enforcement has acted intentionally or in bad faith. So that there just answered my own question. This is now the 5th time they are stating that somebody has acted in bad faith or intentionally lied. Also, as this court is aware, Mr. Allen has filed 2 separate motions to dismiss based upon law enforcement's destruction of evidence. One of those motions was heard on March 18th, 2024, with the court denying said motion on April 2nd, 2024. To prevail a motion to dismiss as it relates to the destruction of potential useful evidence, the motion to dismiss requires the defense to prove that law enforcement acted in bad faith. Pimentel versus State 181. At the March 18, 2024 hearing, defense counsel was attempting to provide evidence to the court that law enforcement had acted in bad faith over the course of this case. At that time, this court was aware that law enforcement had fabricated facts contained in the June 14, 2023 report, thereby acting in bad faith. Yet this court never alerted the defense, and therefore law enforcement's bad faith was not made part of the record. Even if this court would still claim that such a fabrication in a report would not have changed her ruling on the motion to dismiss, the fact that the defense was not able to include that information on the record for the Court of Appeals should be necessary. Additionally, had Judge Gall alerted Mr. Allen's attorneys of Carroll County Sheriff's fabricated statement in that report, the defense could have used that fabricated statement when pursuing their Franks motion and motions to dismiss in order to provide additional evidence of intentionally and bad faith on the part of CCSO. Furthermore, by failing to provide this information to Mr. Allen's attorneys, Judge Gall prevented the defense from investigating this fabricated story, including through depositions. Judge Gall should have alerted Mr. Allen's attorneys of CCO's fabricated facts written in their police report well before the March 18, 2024 motion to dismiss, and her failure to do so provided a rational inference of bias. Do you see where this is all going? I hope so. Because of the fact that she's not a witness doesn't work out, this is going back to the Supreme Court. Judge Gall is now a witness in this matter as to Tobe Lesenby's credibility. Given that Judge Gall is the only individual who knows that she did not direct the CCSO office to ignore the subpoena and leave Mr. Baston at Westville despite the contrary assertions in the CCSO report, she has become a witness to Tobe Lesenby's truthfulness and to the fact that the information contained in CCSO's report is false. The credibility of a witness is always an issue for the jury Stanley versus State. If Judge Gull's story is correct, then she had a ringside seat to the intentional behavior of the CCSO and or the bad faith of the CCSO in that it, one, intentionally ignored a valid defense subpoena for a defense witness, and then two, fabricated a story in a police report claiming that the sitting judge on the case authorized the CCSO to ignore the valid defense subpoena. In this scenario, Judge Gull is a witness. At future hearings and at trial, the defense should have the ability to cross-examine Tobe Lesenby on these contradictory stories with questions similar to the following. Attorney: Mr. Lesenby, the defense attempted to bring a witness named Robert Bastin to testify at a hearing concerning his observation of guards abusing Richard Allen in a variety of ways at Westville. But your office ignored a valid subpoena to bring that witness to a hearing. Isn't that right? You did not want the judge to hear the testimony of that witness because it would support the defense's contention that Richard Allen was being abused and should be moved to the Cass County Jail closer to both his family and attorneys and away from the abuse. You wanted Richard Allen to remain in the Westville prison so that he would continue to be housed far from his attorneys and family while emotionally vulnerable to the abuse he was suffering at Westville. Same old song and dance with the defense. Same old song. Worse yet, you then lied in a report claiming that Judge Gull advised you that it was okay to leave Bastin behind. You lied about that in your report. Judge Gull never told you that it was okay to ignore a valid defense subpoena, did she? I'm handing you Exhibit 85, which is the June 14, 2023 report from CCSA, in which you claim that Gull gave the directive allowing you to ignore the subpoena, etc. Because the defense is claiming that law enforcement has acted in bad faith, and bad faith is an important component in its motion to dismiss, as well as the 4 Franks notices, it must be able to call Judge Gull to the stand to testify concerning the false statements contained in the CCSO's June 14th, 2023 report. Judge Gull's testimony is especially vital concerning the defense motion to modify the safekeeping order, as well as their Franks motion and motion to dismiss. Calling Judge Gull to the stand to testify as to the fabricated facts contained in this report is especially important when the very witness who is in the subject of this report, Robert Bastin, would have testified about Richard Allen's treatment at Westville, which directly led to the deterioration of his mental state and false statements concerning his involvement in the crime. This is their ploy to try to get rid of his confessions. We get it now. We see it. All right. The defense plans on issuing subpoenas and calling Judge Gull to the stand at future hearings and at trial to testify that she never directed CCSO to ignore a valid subpoena and also never advised CCSO to leave Robert Bastin behind if he, Bastin, did not want to attend the June 15, 2024 hearing. Now, I'm going to stop once again. There is no evidence. That's not the word that I'm looking for, but you'll understand it in a minute. There is no way the defense can confidently say that Bastin would have testified to any of that information because he didn't want to go. He didn't want to be a part of it. So how can they confidently say that is what he was going to testify to? Judge Gull should recuse herself from this matter as she is now a witness in the proceedings. See what I said in the beginning? This is exactly what they're going for. Judge Gull's failure to admonish the CCSO may cause law enforcement to believe that they can create fabricated stories in this case with no consequences. Despite having the CCOS report since June 20th, 2023, to this day, Judge Gull has failed to admonish the CCSO for filing a report that contains such a flagrant falsehood and which is arguably an attempt to cover up their illegal actions in ignoring a valid defense subpoena. Judge Gull's failure to address that fabrication in any fashion whatsoever provides a basis for the state's witnesses to believe that they can freely fabricate stories which subvert justice for Richard Allen without consequence. This provides a rational inference of bias. Judge Gull continues to errantly accuse the defense of improperly filing ex parte documents. In its May 31st, 2024 order, this court continued to claim that the defense is to blame for ex parte pleadings that were accessible to the prosecution. On March 7th, 2024, Attorney Rozzi alerted Judge Gull about his grave concern surrounding McClellan receiving the ex parte documents. It took Judge Gull 13 days to respond to this urgent matter. In her March 20th, 2024 emailed response, Judge Gull wrote to the defense counsel, "I would encourage you to educate your staff on how to properly file pleadings." Attached is a printout from the Dropbox DocsPop filing process of the February 26, 2024 ex parte document that court staff mishandled, causing accessibility of the document to the prosecutor. Exhibit A. That is Exhibit B. This is Exhibit A, which I'll show you after I'm done with this one. All right. It should be noted that upon receiving the February 26, 2024 pleading, court staff would see in bold font and capitalized letters at the top of the pleading the following: ex parte pleading to be placed under seal, which should have easily alerted court staff of the ex parte nature of the document, causing them to follow the proper procedures in processing an ex parte pleading. The staff for the defense filed the ex parte documents correctly. The DocsPop printout shows that the only service contacted listed on this ex parte filing were Brad Rosie and Andrew Baldwin, not Nicholas McClellan, James Luttrell, or Stacy Diener. Furthermore, the printout shows all documents were marked as confidential. Footnote: in her May 31st, 2024 order, Judge Gull seemed to believe that parties can only file ex parte documents through the Odyssey platform. If so, she is incorrect. Parties may also file ex parte documents through the DocsPop platform. which is the platform defense staff utilized when they correctly filed the February 26, 2024 ex parte document in this case. Over the course of this case, defense staff has used both Odyssey and DocsPop platforms where e-filing ex parte documents. It is telling that the tutorial Judge Gull sent to the defense details how court staff should process ex parte documents they receive in the Odyssey platform, not the DocsPop platform. There is nothing else further that the defense can do to prevent these documents from being made public or misdirected to the prosecution. After the defense correctly files the ex parte document, the defense must then trust that the court staff has been properly trained on how to navigate on ex parte filing, whether it is filed using the Odyssey or DocsPop platform. In this case, after the defense correctly filed the ex parte motion, somehow court staff erred in how it processed the document into the system, causing prosecutor McLeland to have access to the ex parte document. In her May 31st, 2024 order, Judge Gull detailed how she sent the defense a tutorial paper authored by JTAC explaining the process. The court implied in said order that she sent the tutorial to the defense in order to assist the defense in learning the proper process of how to file an ex parte motion. Judge Gull's presumption that this tutorial assisted the defense is inaccurate for three reasons. One, the defense was not errantly filing ex parte documents. Two, the tutorial Judge Gull sent to the defense had nothing to do with assisting practicing lawyers on how to file ex parte documents. And three, the defense continued to file ex parte documents in the exact same manner it has been filing before Judge Gull ever sent the tutorial to the defense, and there was no issues. The tutorial Judge Gull emailed to counsel is exactly intended to assist court staff and clerks in how to properly handle ex parte documents after the private practitioner has filed the ex parte document. In other words, the document that Judge Gull refers to in her order does not in any way assist the practicing lawyer in filing ex parte documents, as it is a tutorial for court staff. Please find attached printout of the tutorial Judge Gull sent the defense marked as Exhibit B, which also includes the cheat sheet referenced in the letter from Office of Court Services. Even though on its face, the tutorial clearly appears directed to assist court staff in understanding how to process accept ex parte filings, the defense staff still reviewed the tutorial sent by Judge Gull to determine whether any part of the tutorial was meant to assist a practicing attorney in how to file an ex parte document. It does not. When defense staff clicked on the link detailed in Step 1 and attempted to sign in, they were presented with a prompt that states, "You are not authorized to use this site." This is because, again, the tutorial that Judge Gull proclaimed in her order as helpful to the defense was actually meant for court staff. Wow. Now, I think the defense has a point there. If you're a judge and you're going to send a tutorial to the defense, you should probably review it and make sure it applies to them. Wouldn't you say that's fair? Got to give it to the defense on that one. Judge Gull has failed to admonish Prosecutor McClelland for improperly reading ex parte pleadings while continuing to denigrate defense counsel. The pleadings errantly made accessible to Prosecutor McClelland were clearly marked ex parte, meaning they should not have gone to anybody but just been filed with the court. The defense became aware that Prosecutor McClelland read the ex parte documents based upon a March 6, 2024 prosecution filing in which the prosecution directly quoted from defense's ex parte filing from February 26, 2024. This document was clearly marked in capital letters at the top of the document, ex parte pleading to be placed under seal. After reading Prosecutor McClelland's March 6, 2024 filing and realizing that McClelland had reviewed a defense ex parte document, Attorney Rossi sent an email to Judge Gull and one of Judge Gull's staff members, as well as to Nick McClelland. Find attached copy of said email marked as Exhibit C. The email respectfully questioned how an ex parte motion was made accessible to the prosecution. Then on March 7, 2024, Prosecutor McClelland filed a pleading in which McClelland, finally admitted that he also had access to 3 other ex parte filings. That is not a good thing, you guys. Not good at all. Despite the clear marking of ex parte on the documents, Prosecutor McClelland chose to read those ex parte documents rather than promptly deleting them and alerting the defense of the misdirected filings, as required under Indiana Rule of Professional Conduct, IRPC 4-4B. A lawyer who receives a document relating to the representation of the lawyer's client and knows or reasonably should know that the document was inadvertently sent shall promptly notify the sender. Footnote, after reviewing the record, the defense believes that Prosecutor McClelland actually reviewed only 2 ex parte filings, as 2 of the filings that he has referenced in his pleadings he identified as ex parte are not actually ex parte filings. Goodness gracious. Prosecutor McClelland never contacted defense counsel after receiving the ex parte documents as required under RPC 4-4B. The defense only learned of this violation upon reviewing McClelland's March 6, 2024 pleading in which McClelland audaciously quoted directly from the ex parte document, thereby making this quote available for public view. The act of McClelland reading from defense's ex parte documents provided the prosecution with an entirely improper glimpse into the manner in which Mr. Allen's attorneys would be defending him. This is yet another example of subversion of Richard Allen's due process rights. This court has failed to reprimand the prosecution for reading ex parte documents or to even address the issue in any way whatsoever. Nor has Judge Gull filed a pleading in which Judge Gull, publicly proclaimed that she is referring Nick McClelland to the Office of Judicial and Attorney Regulation, Executive Director Adrian Meering, for the office to enforce the rules or determine counsel's ethical misconduct. This court publicly declared in its April 30th, 2024 order that it was referring defense counsel to the Office of Judicial and Attorney Regulation concerning a short and bland press release that defense counsel set out to media sources when no gag order was in place, and after the prosecution and law enforcement had conducted multiple press conferences and issued multiple press releases over the course of the investigation. Meanwhile, on the much more serious allegation of McLeland reviewing ex parte documents and violating our IRPC 4.4b, Judge Gull has said or done nothing. Judge Gull is clearly treating the prosecution differently than the defense counsel, and this provides a rational inference of bias. This court offered its handpicked public defenders an opportunity for a hearing on the Franks motion, but denied the same opportunity for attorneys Baldwin and Rozzi. In her May 31st, 2024 order denying the defense request for disqualification, this court maintained that it has no bias against defense counsel. Footnote, this quote is taken from Judge Gull's April 30th, 2024 order or judgment of the court concerning the prosecution's request that defense counsel be found in contempt, which Judge Gull did not find them in contempt. On January 2024, this court denied Baldwin and Rozzi's request for a Franks hearing. At that point in time, the court had failed to rule on the Franks request for over 4 months. Yet within 4 days of their re-entering their appearance on the case, Judge Gull denied their request without a hearing. The judge doesn't have to give them a hearing. That's the thing. Do I wish that she would, just to dot her I's and cross her T's in this case? Yes. But she doesn't have to have a hearing. So, with that being said, remember that. Judges order and deny things all the time just based off of the motions that she gets and reads. They don't have to necessarily have a hearing. However, after Baldwin and Rozzi were taken off the case in October 2023, Judge Gull informed her newly handpicked public defenders that they should review prior counsel's pleadings and either adopt those pleadings or make their own. In that November 14, 2023 CCS entry, it was mentioned that Judge Gull informed the new public defenders, Screamin and Labrato, that if defendants' new counsel informed the court they intended to pursue the Franks motion, the court will schedule a hearing. She did do that. I absolutely remember that. She did say that. Such action demonstrates that this court is punishing Richard Allen due to her bias against attorneys Baldwin and Rozzi, in that after they re-entered their appearances, she quickly denied Allen's original counsel a hearing on the Franks motion while offering the replacement public defenders an opportunity to have a Franks hearing soon after their appearance on the case. This disparate treatment of attorney Baldwin and Rozzi compared to this court's treatment of the prosecution and even of the replacement public defenders provides a rational inference of bias against the defense counsel Baldwin and Rozzi, and therefore against Richard Allen. In its order, the court claimed that it is irrational and unreasonable for the defense to assert that as lawyers with 70 years of combined experience, they have never had a judge provide a hard end date for a trial. Calling defense counsel irrational and unreasonable shows bias, especially when the court is wrong in its understanding of Jury Rule 4. This court unfortunately continues to malign defense counsel by calling them irrational and unreasonable for their averments that courts around the state of Indiana never set a rigid day for the trial to end. Implicitly, the court is also averring that defense counsel are lying about their experiences in other courts around the state of Indiana. Furthermore, this court maligns defense counsel concerning its knowledge of the jury rules when it is the court that incorrect in its assessment of the jury rules. At the May 7, 2024 pretrial hearing, the court stated, "Well, you understand. Well, maybe you don't understand. Jury Rule 4 requires that I issue summons to the jury with the dates of the trial. Jury Rule 4 requires that I issue summons to jurors with the dates." Transcript, May 7, 2024 hearing, page 12, line 13. The court cited Jury Rule 4 as a basis for limiting the time of the trial. However, Jury Rule 4 does not ever discuss the length or dates of the trial or require courts to place a hard end date for a trial. Jury Rule 4 states that not later than 7 days after the date of drawing of names from the jury pool, the jury administrator shall mail each person whose name is drawn a juror qualification form and notice of the period during which any services may be performed. Jury 4 is primarily referring to the time span or term during which citizens need to be on the alert that they could be summoned in for jury duty, e.g., when they are on call for possible jury duty. The prospective juror needs to be aware that over the course of a specified number of months, the court may summon them to appear in court as a potential juror at a later date. Jury Rule 4 further states that when summoning a prospective juror in for jury duty, that the summons shall include the following information: directions to the court, parking, public transportation, compensation, court policies regarding the use of electronic communication devices, i.e., cell phones, PDAs, smartphones, etc., attire, meals, and how to obtain auxiliary aids and services required by the American with Disabilities Act. Note that Jury Rule 4 does not require the court to provide the dates of the actual trial or the length of the actual trial, nor does Jury Rule 4 require the prospective juror to be advised of the beginning date or end date of the trial. Now I can tell you this. After watching numerous trials, I have never, ever seen a judge put an end date on trial. Judges always say, this trial is expected to last 8 weeks, 9 weeks, 3 weeks, 1 day, 3 days, but may go longer depending on what happens with the witnesses and things like that. I've never actually heard them say, this trial will be over on this date. All right, Jury Rule 9, term of jury service states, a person who appears for service as a petite juror serves until the conclusion of the first trial in which the juror is sworn, regardless of the length of the trial or the manner in which the trial is disposed. Once summoned in and selected as a juror, Jury Rule 9 is the jury rule that comes the closest to referring to the length of the actual trial. Note, the jury rule 9 places no limit to the length of an actual trial once a juror is selected. Nor does jury rule 9 place a hard end on the conclusion of any trial. Indeed, by stating that the juror serves until the end of the first trial, regardless of the length of the trial, the authors of the jury rules innately understand the courts will not have foresight to include an actual end date to a trial. As proof, in larger counties, jurors are summoned for a particular day and would be chosen to serve on any number of trials of varying lengths. In spite of Judge Gall's proclamation at the May 7, 2024 hearing, Indiana jury rules do not provide or require a mechanism to limit the length of the trial whatsoever, including as it relates to the information contained in the jury summons that the court sends to citizens pursuant to Jury Rule 4. Judge Gall's errant interpretation of Indiana jury rules created a situation in which Mr. Allen was required to seek a continuance of a speedy trial in order to assure for himself a trial where he could thoroughly present his defense without time restrictions. Judge Gall's bungling of Mr. Allen's speedy trial right due to her misunderstanding of what the jury rules require in the summons only negatively affected the defendant and his constitutional rights, not the prosecution, and thus provides a rational inference of bias against the defense and Mr. Allen. Footnote: in Marion County, for example, prosecutive jurors arrive and gather in a large room not knowing which court or what trial they may be called upon to serve, as often multiple jury trials are conducted at the same time and on the same day. The prospective juror could be asked to serve on any one of those trials. Additionally, at the May 7, 2024 hearing, Judge Gall cited several cases over which she has presided that lasted less time than the defense has requested on this case, essentially chastising the defense for the amount of time it was seeking for trial. The length of a trial is determined by the number of witnesses, the amount of evidence, the length of the investigation, and the complexity of the issues involved. This is the case of State of Indiana versus Richard Allen, with its own set of facts, challenges, and potential pitfalls that could cause the trial to last beyond what the parties expect. For example, several witnesses reside 125 miles away. If those witnesses fail to appear in spite of being properly subpoenaed, the trial may be delayed while the parties try to determine how to deal with a witness whose car may have broken down or who may have simply ignored a valid subpoena. These situations arise in trial, especially in a factually complex trial with approximately 185 witnesses identified by the parties. Additionally, of the approximately 185 witnesses identified by the parties, a dozen or more are expert witnesses, whose testimony will generally take longer and will be more complex than fact witnesses. For this court to call defense counsel irrational and unreasonable for stating the truth that they have never had a judge set a hard end date to a trial provides a rational inference of bias against the defense. Additionally, it is shocking and disconcerting that the court refused to place a limit on the time allotted to the prosecution, but absolutely limited the time for the trial, thereby limiting Mr. Allen's time to present his defense. Under the court's prior order, the trial was to last from May 13th, 2024 through May 31st, 2024, thereby allowing approximately 13 days for opening statement, testimony, evidence, rebuttal evidence, surbuttal evidence, arguing of final instructions, and closing arguments of both parties. If the prosecution took 8 days to present their case, this would only leave 5 days for Mr. Allen to present his witnesses, which include at least 5 expert witnesses without even factoring in rebuttal evidence, surbuttal evidence, arguing of final instructions, and closing arguments. The hard limit on the end of the trial denies Mr. Allen his Sixth Amendment right to confront witnesses, his Sixth Amendment right to the compulsory process for witness, and his 14th Amendment due process right to present a defense. In the context of its request for Judge Gull to disqualify herself, this court's maligning of defense counsel as irrational and unreasonable, when in fact it was the court that was wrong in its understanding of jury rules, and also wrong in its claim that courts statewide provide a hard end date to a trial, offers a rational inference of bias against the judge. So, I also think the defense makes very good points in that section. A judge cannot limit the amount of time a defense attorneys have to put on their case. They can ask them to speed it up. Absolutely, I've seen that before. Things are running way too long. The jurors are tired. They're not focusing. Is there any way you could speed things up? I have seen them do that. But to tell them that the prosecution gets whatever amount of time it has to present their case and they only get certain time left, I haven't personally seen that. Okay. Judge Gull's May 31st, 2024 explanation for her denial of defense motions without a hearing provides a rational inference of bias. I personally do not agree with this. Judges deny motions all the time without hearings, as I said before. But they got to try. In its May 31st, 2024 order, when explaining why the court denied several defense motions without hearings, the court stated if pleadings on their faces are not supported by the law or admissible evidence, judicial economy does not require a hearing. This court knows very little about this case, and they're assuming that, especially compared to the lawyers litigating the matter. I would agree that she doesn't know as much as the lawyers, but she knows more about this case than they think. Therefore, how could the court determine what evidence would be admissible or inadmissible until a hearing takes place and the defense moves to admit the evidence, subject to possible objection by the prosecution? Well, you put it in your pleadings and your motions why all this is. Why do you then have to come forward face to face and say exactly what you said in your motion? She can read. She can put two and two together of what you're telling her. She doesn't have to have you face to face to tell her what's in front of her in writing. That's why you wrote the motions and the pleadings in the first place. This court knows very little. Judge Gull's claim that defense evidence is inadmissible before conducting a hearing and before listening to the defense's contextualization of the evidence surrounding their legal arguments provides a rational inference of bias against the defense. Once again, she can look at what you're saying about your evidence and make a determination if it's admissible or non-admissible. This happens in courts every day. Now, it is my opinion that because this is such a high-profile case, the judge should have been having hearings on all of this, or a good majority of it. Okay? Just to cross all the T's and dot the I's. We wouldn't be in this situation having these accusations if she would have had some hearings. My opinion. And that is based off of all the trials that I have watched throughout my lifetime. This court's denial of defense motions without a hearing based upon the reasons this court cites in its May 31st, 2024 order establishes that this court is prejudging defense evidence as inadmissible. Also, this court claiming that the law does not support the defense pleading before this court even hears any evidence is additionally proof that the court is prejudging evidence. This court's denying the defense's request contained in its pleadings without a hearing, based upon her prejudging evidence, provides a rational inference of bias. In the future, if this court denies defense motions based upon the court's belief that the defense pleading is not supported by the law or admissible evidence, the defense then requests this court to identify the evidence cited in the defense's pleading that this court believes is inadmissible, and then to explain why the court believes the evidence is inadmissible. Also, instead of simply stating denied without hearing, the defense will request the court to explain why the pleading is not supported by the law. I think that's professionally reasonable request from the defense. If she's not going to hold hearings and she's just going to deny things, she should have to explain why that is. Even concerning something as basic as a request for a recess, Judge Gull shows favoritism to the prosecution. Really? You're going to get that petty? Okay, here we go. In her May 31st, 2024 order, Judge Gull expressed that she does not show favoritism to the prosecution. However, Judge Gull has shown her differential treatment between the prosecution and defense in a variety of ways. Some are easily identifiable and some are less perceptible. For example, because cameras have not been allowed in the courtroom, it is difficult to hear Judge Gull's angry tone when addressing the defense versus how she speaks to the prosecution, and also to visualize the court's disdain facial expressions she makes towards the defense versus the prosecution. Although it may seem petty or trivial to the court, the defense offers an example of her disparate treatment concerning something as mundane as how the court handles a simple request for a recess during a hearing. At the June 15, 2023 hearing, Prosecutor McClellan requested a recess, and the following transpired. McClellan: Judge, I have two witnesses. Could I ask the court for a short recess just so I can use the restroom? Judge Gull: would counsel approach? Sidebar conference conducted. Judge Gull: I just want to know what kind of where we're at. You got two witnesses? McClellan: Tony Liggett and the Westville warden. Judge Gull: okay, Do you want a break for lunch? Rozzy, I don't, but I'm Judge Gull. Okay. McLeland, so I don't care. I can. Inaudible. Judge Gull, yeah, we could take a quick break. How long? McClellan, I don't mean to be a pain, but Judge Gull, no, that's all right. How long do you think you'll be? McClellan, downstairs and right back up. Judge Gull, no, I mean in your witnesses with your evidence. Oh, Judge Gull, ding dong. I don't care how long it takes you to go there. No, I don't care about that. McClellan, I don't really think too long. Inaudible. Tony about the transportation resources, and then Galleppo just to address allegations they made in their safekeeping. Judge Gull, so like another like hour and a half? McClellan, I guess. I just couldn't. Judge Gull, let's just break for lunch. I know you don't want to, but too bad. Rozzy, I'm fine with whatever. Judge Gull, okay, let's just break for lunch. Rozzy, I don't have anywhere else I need to be. Judge Gull, well, I know you don't because you were supposed to be here for 2 days. 88. However, at the May 7th, 2024 hearing, the court treated the defense much differently when the defense sought a short recess to confer with their client on urgent matters concerning the positives, negatives of continuing Mr. Allen's speedy trial due to Judge Gull's hard end date of May 31st, 2024. Following a back and forth exchange between Judge Gull and defense counsel concerning the defense needing more time for trial than Judge Gull was allowed, this occurred. Rozzy, can we have 5-minute recess? Judge Gull, why? Rozzy, I would like to speak with my co-counsel here and have a discussion about the business issues such as scheduling, not here in a courtroom where everybody's listening to us. We've got, 50 staff members in this courtroom, people sitting behind. There's no privacy, and I'd like to talk to him in the hallway about some of the logistics of this so we can solve this problem so that he, Mr. Allen, can put on a defense. Judge Gull, does the state of Indiana have any objections to a recess? McLeland, no, Your Honor. Judge Gull, all right. Jody, you can go off the record. Judge Gull did not playfully call Brad Rozzy ding-dong, but instead questioned Rozzy's reasons for seeking a recess. Then Judge Gull surprisingly asked the prosecutor if he had any objection to seeking a 5-minute recess so that defense counsel could talk to their client about the important matters concerning seeking a continuance of a speedy trial due to the trial court's unwillingness to provide more time to the defense at trial. Oh my goodness. All right. When a defense attorney requests 5-minute recess to talk to their client on such weighty matters as their constitutional rights related to continuing a speedy trial, it should be met with a simple of course and should not require approval of the prosecutor. The fact that Judge Gull treats the defense differently on such a basic matter as a request for a recess provides a rational inference of bias. I know this is repeating myself, but I can tell you out of the many, many trials that I have watched, this is how it is with judges. They do this for the prosecution, and this is how they treat the defense. In many, many cases. And in my experience, even if Judge Gull is removed, the next judge will probably do the same thing. Because that's just how they do things. Does it upset me? Absolutely. The court failed to address the appearance of bias which exists in this case. Judge Gull claims in her order, as counsel should know, criminal cases are tried in the court of law, not in the court of public opinion. However, the standard for recusal is not just whether actual bias exists, but also whether the appearance of bias exists. The judge must consider both actual bias and the appearance of bias when determining whether to disqualify herself. Judge Gull appears to conflate the general concept that on occasion the public will vehemently criticize a judge with the defense's specific intention that many in the public are particularly criticizing her for what the public perceives is actual bias against the defense. The emails which the defense attached to the motion and the memes the defense referenced in the motion detail how the public believes that Judge Gull is biased against the defense. The defense agrees with the court that general complaints by the public concerning the court's rulings should not cause her to disqualify herself. However, that is not what the defense is discussing in its motion. Although the defense believes actual bias exists, it is the appearance of bias against the defense about which the public has complained. It is the appearance of bias against the defense about which the public has written the Indiana Supreme Court. It is the appearance of bias against the defense about which the public has written Judge Gull. And it is the appearance of the bias against the defense, the existence of which Judge Gull should recognize and for which Judge Gull should voluntarily recuse herself. Now, this is so dangerous of setting precedents, okay? Because they're saying it's the appearance of bias against the defense. As I said, this is done every day in court against the defense. So if we're going to let them do, it's the appearance of bias against the defense, and they win this off of that, all trials are screwed. Because if you don't like a judge, that's exactly what you're going to say to try to get a new judge on the case. And that is a scary precedence. Failure to address other issues contained in the first motion to disqualify. The court addressed a few other defense issues contained in their second motion to have Judge Gull disqualify herself. The defense stated by those reasons as well and does not waive those issues for purposes of appeal. However, in its May 31st order, this court failed to address all issues contained in the defense's first motion to have Judge Gull disqualified, which the defense incorporated into its second motion. The defense requests Judge Gull to review the first and second motion to disqualify and consider whether she feels obligated to disqualify herself from this case based upon the itemized reasons contained in those motions, as well as in this response. Conclusion. The defense wishes to move forward and have the court conduct hearings. Most immediately, the request to have Richard Allen removed from the DOC to either Cass or Tippecanoe County jails while waiting trial. The motion is intended to respond to Judge Gull's order for purposes of preserving the issues for the record, and so that Judge Gull may consider whether or not she feels obligated on her own to recuse herself from this case, which remains an ongoing obligation, whether or not the defense is seeking her recusal. Wherefore, the defense files its response to Judge Gull's May 31st, 2024 order of judgment of the court concerning her denial of the defense request for disqualification. So my question to you is, if Judge Gull does not recuse herself, based off of what we heard, how many of you think they are going to go to the Supreme Court and try to get her booted? If you think that they're going to go to the Supreme Court, put a 1 in the chat. I'm just curious what everybody thinks here. So we've got some coming through. Some ones. Okay. So they say they're not trying to delay any hearings or the trial itself in this motion. But remember, in the back of their minds, that October date is coming up faster than we know. And if she does not bring him to trial by the 2-year mark, is it the 1 year or 2-year mark? They have to issue a bond for him. So is the defense truly playing this off as Judge Gull is so bad, or do they realize that their defense strategy has gone out the window and they need more time to come up with a new strategy? And are they trying to shoot for that October date where a bond has to be given? Now, in my mind, I would be like, why? Why shoot for October for a bond to be given? If a bond is given in this case, you know it's going to be such a high amount that Richard Allen can't pay for it. So he's going to be in jail anyway. So what is the defense's motives here? Because there's no guarantee that if another judge comes in, that judge is going to allow their odinist theory and defense to be played out. Even if hearings are held. So where do they go from there? That is my question. Have they really, truly thought this out? CJK says they have a judge in mind. They want a specific judge. Maybe. Lynn says it's more likely the Supreme Court will disqualify the defense. Gibbo was saying what I was saying. They won't go to SC. They can't get bond anyway. They are delaying, not the court. Why are they delaying? If they know that they can't, the bond isn't going to help because it's going to be so high, why are they delaying? Have they realized that their defense, the road that they've gone down, is not going to work for Richard Allen? And they need to come up with something new. And they need time to do it. Why delay? There's been discussion on that bond speculation. Motive is more complaints. Plus strictly no bond on child murder in Indiana. I saw it last night. Yeah. They have no case. They have no defense. That is the problem. They have no defense right now. Especially if Judge Gull or any other judge throws out all of the Odinist stuff. They buckled down on the Odinist defense theory. And they did not come up with a backup. So let's see here. I'm backing up a little bit here. Just to see what kind of comments you guys are saying. Like this comment. I suppose next thing, Rozzy and Baldwin will want to pick their own judge, right? Appearances are often misleading, but people make judgments based off of appearances. Yeah. Some channels were encouraging folks to email complaining about the judge and how the defense are using. I know. The public's opinion is because of him and Hennessy feeding Bob Mata. Okay. There are exhibits to this filing. Yep, I'm going to show them here. Okay. Present, share screen. Okay, so what this says is filing description. Verified ex parte motion for hearing on funding for expert services. Filing type, M, motion filed. Filing status, accepted 2/26/2024, 8:10 a.m. Document name, gives the document, motion is the name. Document type, lead, attachments. Filing description, proposed order. Filing type, ADMP ROP. So it's a proposed order filed. Document type, lead, confidential. And it does say confidential up here. Then if you go to page 2, it does say envelope, verified ex parte motion for hearing on funding for expert services. Nowhere in here does it say to be sealed, like the defense is saying in their motion. I don't see that anywhere. And they say they specifically put that this should be sealed. I'm not seeing that anywhere on here. Nowhere. All I see is confidential. And verified ex parte motion for hearing on funding for expert services. That has nothing to do with what they said was in here in the motion that we just read. Okay. Stop screen. Exhibit B. Okay. There we go. Okay. Office of Court Services. Mary Kay Hudson, Executive Director. This was filed 6/18/2024 at 10:59 a.m. To all judicial officers, all circuit clerks, from Jeffrey S. Wise, Deputy Director of Legal Support and Statistics, dated March 27th, 2024, proper processing of ex parte filings in Odyssey. Specifically says in Odyssey. As a reminder, ex parte is Latin terms meaning by or for one party. The term refers to an attorney's or unrepresented party's communication with a judge or legal proceeding conducted without notice to and outside the presence of other parties. Typically, ex parte proceedings are permitted only when a party needs urgent relief that cannot wait until the adverse party is informed of the request and given an opportunity to respond. Ex parte court documents are filed via e-filing or conventional filing, must be handled differently than other filings. Documents that are ex parte should be marked with the document security group, access limited to court and clerk. Right there. None of that was on their filing. This ensures that other parties or attorneys cannot access the filed documents. See the cheat sheets on how to process ex parte filings in your e-filing review queue in order to make sure these documents are marked properly before they are added to Odyssey. Choosing the wrong document security group will expose the filing to other parties. If you have questions about the various document security groups in the Odyssey, please contact the help desk. And it gives instructions to the clerks how to file these. Now, I'm not going to go through all these, but I mean, it's basically a step-by-step for the clerks on how to put these into the record. So, let me bring up the last one. Here we go. From Brad Rossi, sent Thursday, March 7, 2024, 10:13 a.m. to Leslie Ross, Francis Gall. CC, Nicholas McClelland. Andrew J. Baldwin. Subject, ex parte filing. Okay. Judge Gull, you may be aware that I filed an ex parte motion for funds on 2/26/24, which contained confidential information regarding our client's defense. We have double checked and confirmed that the only two individuals CC'd on the motion were myself and Andy. See attachments. This morning I received an e-notice of a filing by Mr. McClellan requesting Dr. Westcott's records and his filing. There exists specific quotes from my ex parte filing on 2/26. Unless I'm missing something here, this would suggest that Mr. McClellan has a copy of my motion. Naturally, this is concerning. In an effort to not jump the gun on this, my staff members did reach out to Karen in Carroll Circuit Court to confirm that she processed the motion in accordance with the ex parte confidential filing procedure, and she assured my staff that she did. I'm not looking to point fingers here, but I think it's fair for me to inquire as to why our client's ex parte filing is not being treated as confidential filing. I also think it's fair to inquire as to why the prosecutor would not only read the filing, knowing that it is noted as an ex parte pleading to be placed under seal, but moreover, why, after reading the filing, the protected information would be reduced to a pleading and publicly filed by the state. In a normal situation, I would simply pick up the phone and call Mr. McClellan to get to the bottom of this matter, but he has already made it clear to Andy and I that he will not communicate with us over the phone. I have no interest in engaging in dueling emails over such an important matter, so I'm seeking your assistance. I would appreciate your thoughts on this and how to remedy the situation. Of course, I'm open to Mr. McClellan's input as well. And finally, I'm happy to discuss this by phone. Also, there's the fact that the state's pleading is currently accessible to the public. Can't put the genie back in the bottle, but the remedial measure of removing the filing would be appreciated. I look forward to hearing from you. BR. So, what are you guys' thoughts on this? You think Gull should be removed? You think Gull should stay? Do you think that it's really going to help the defense to get another judge? Then work on a fake alibi. This is why SC needs to intervene, because both sides the same exact things about the other side, lying, delaying, etc. Alibi, Richard was looking at the fish. Rozzy got Alan in the sharpshooting, stopping him from confessing. Baldwin with the cripple cross face. Don't do it, Alan. We are your friends. Labrado also said he thought R.A. was innocent. Yes, he did. Hang on 1 minute, guys. I got to take this for my husband. All right, I'm back. Labrado filed for a third attorney. He was trying to stay on the case. He knew what they were doing and wanted some gravy. Let's see here. In all my years of watching true crime, I have never seen a defense like this make such bizarre choices. It's like a circus. Justice for Abby and Libby. Exactly. They lied to the public that they were forced to get public funds. But when Lobrato stated he thought he was innocent, he was not his lawyer at the time. I was granted ex parte once. Judge was not happy. I brought slippers and vodka. I agree with this. This is why I said I wish the Supreme Court would have taken them all off at the same time the first time. Start over, new prosecutor, new defense team, new judge. Stop the circus. Well, they didn't do that, so the circus has continued. Agree, Andrea, they need to stop delaying and filing the same things over and over and get on with the trial. I agree. I'm happy for McClelland's opinions as well. Judge, he looks at my filing that I filed wrong. This is a good point. If they truly wanted her gone, why didn't they go back to the appellate court right away and fight to get her removed? Instead of just keep requesting her to recuse herself. CJK says, nope, not removed. A debacle. Yes, I agree. I don't believe replacing the judge will help the defense case, but I do think the Supreme Court needs to step in. Something needs to be done with this circus. Yeah. I don't think so. I think the moderator would be the higher court. You know, and they file this stuff and they shoot it off so quickly sometimes, and she's just got to shake her head at times and be like, I'm not putting up with this. And that's why she just denies it instead of having a hearing. If they were more organized and thought things through instead of just shooting things off, she may have granted hearings on this stuff. She may not have. I don't know. But all the pettiness and crap needs to stop. We need this trial to go forward. It should be a fair and impartial trial for the defendant so that the jury can decide for themselves if Richard Allen is guilty or not. That is my opinion. This was done first for the record. Yes, with the filing, they are using all remedies before OA. This way, Skonan can't say they didn't. Yes, I agree with that too. They wanted things corrected on the record and everything else. They said that right off the bat. They had to correct some errors. Well, they may have wanted it that way, but she stopped that with the gag order. They've slid by having these Frank's motions and everything else go to the public. So I just want, I'm going to repeat it, I want a fair and impartial trial for this man so nobody can say that he was treated unfairly, didn't get the best defense he could, and for a jury to decide if he's guilty or not. Make all the other BS stop. And if that means the judge has to have a hearing to appease the defense, then fucking have a hearing. And then after the hearing, explain why you are denying their requests. Don't just deny it. Because enough is enough. This back and forth is wasting time, and it's just BS, as far as I'm concerned. It's hurting the families of the victims by you keep drawing this out. You say you don't want to delay anything, but in reality you are. Both sides need to man up, grow up, and get this case settled. Bring it to trial. That's my opinion. Chief Justice also said RA had the right to his own lawyers, and that's why they reinstated him. They were not happy Gull wouldn't let him have them, even pro bono. Well, he's got them. Now, do your jobs the right way. Stop stalling. Get ready for court in October. The judge have a freaking hearing, listening to this once and for all, either accept it or deny it. And give reasons why it's denied, specific reasons. All right, everyone. Thank you so much for joining me. If you like the fact that I read the whole document to you, let you see it. You heard it all, not just segments. Click that like button. Show me some love. Before we go, I do want to say, Rose, thank you so much for the super sticker. I appreciate it. I will bring you any more information that may come out in the next few days regarding these documents. Now that I'm off of work, I can, get them and do a live on them right away. So thank you for joining me, and I'm sure I'll see you again for Delphi soon. Have a good afternoon, everyone.